U.S. Supreme Court no license necessary. U.S. Supreme Court and other high court. Citations proving that no license is necessary. The right of a citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile, is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty and the pursuit of happiness. Under this constitutional guarantee one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. 1 Thompson v. Smith, Supra. Tech Lines v. Danforth, Miss. 12 S2D 784 inches. The right of the citizen to drive on a public street with freedom from police interference is a fundamental constitutional right. White, 97 Cal. App.3D.141, 158 Cal. RPTR. 562, 566-67, 1979. Citizens have a right to drive upon the public streets of the District of Columbia or any other city absent a constitutionally sound reason for limiting their access. 2 Thompson v. Smith, Supra. Tech Lines v.S. Danforth, Miss. 12 S2D 784 inches. The right of the citizen to drive on a public street with freedom from police interference is a fundamental constitutional right. White, 97 Cal. App.3D.141, 158 Cal. RPTR. 562, 566-67, 1979. Citizens have a right to drive upon the public streets of the District of Columbia or any other city absent a constitutionally sound reason for limiting their access. 4 Berberian v. Lucier 1958-139A2D 869, 872. See also, Schechter v. Killingsworth, 380. p.2d 136, 140, 93 Ares. 273, 1963. The right to operate a motor vehicle, an automobile, upon the public streets and highways is not a mere privilege. It is a right of liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. 3 Kenesha Mills v. D.C. 2009. The use of the automobile as a necessary adjunct to the earning of a livelihood in modern life requires us, in the interest of realism, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. 6 Campbell v. Walker, 78 ATL. 601, 603, 2 Boyce. Dell. 41. The owner of an automobile has the same right as the owner of other vehicles to use the highway. A traveler on foot has the same right to the use of the public highways as an automobile or any other vehicle. 5 Adams v. City of Pocatello, 416p.2d 46, 48, 91. Idaho 99, 1966. A traveler has an equal right to employ an automobile as a means of transportation and to occupy the public highways with other vehicles in common use. 8 People vs. Horton 14 Cal. App. 3rd 667, 1971. The right to make use of an automobile as a vehicle of travel along the highways of the state is no longer an open question. The owners thereof have the same rights in the roads and streets as the drivers of horses or those riding a bicycle or traveling in some other vehicle. 7 Simeone v. Lindsay, 65 ATL. 778, 779, Hannigan, vs. Wright, 63 ATL. 234, 236. The right of the citizen to drive on the public street with freedom from police interference, unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by the courts. 9 House vs. Kramer, 112 NW. 3, 134 Iowa 374. Farnsworth v. Tampa Electric County 57 SA 233, 237, 62 Florida. 166. The automobile may be used with safety to others users of the highway, and in its proper use upon the highways there is an equal right with the users of other vehicles properly upon the highways. The law recognizes such right of use upon general principles. 10 Brinkman v. Pakalike, 84 NE. 762, 764, 41. Eind. App. 662, 666. The law does not denounce motor carriages, as such, on public ways. They have an equal right with other vehicles in common use to occupy the streets and roads. It is improper to say that the driver of the horse has rights in the roads superior to the driver of the automobile. Both have the right to use the easement. 11 Indiana Springs Company vs. Brown, 165 Eind. 465, 468. U.S. Supreme Court says no license necessary to drive automobile on public highways, streets. No license is necessary. Copy and share freely. YHVH. Name 22. A highway is a public way open and free to anyone who has occasion to pass along it on foot or with any kind of vehicle. Schlesinger v. City of Atlanta, 129 SE. 861, 867. 161 GA 148, 159. 12 Holland v. Shackelford, 137 SE 2D 298, 304. 220 GA 104, Stavola v. Palmer, 73 A2D. 13 City of Dayton vs. Debris, 23 Na 2D 647. 650, 62 Ohio App. 232 inches. Thus self-driven vehicles are classified according to the use to which they are put rather than according to the means by which they are propelled. Ex parte Hoffert, 148 Northwest 20. 14 American Mutual Liability Inns. Co. V.S. Chaput. 60 A2D 118, 120, 95 NH 200 Motor Vehicle, 18 U.S.C. Part 1 Chapter 2 Section 31 Definitions. 6 Motor Vehicle. The term, motor vehicle, means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways. 10 The term, used for commercial purposes, means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business, or other undertaking intended for profit. A motor vehicle or automobile for hire is a motor vehicle, other than an automobile stage, used for the transportation of persons for which remuneration is received. 15 International Motor Transit Company vs. Seattle, 251 p. 120 The term, motor vehicle, is different and broader than the word automobile. 16 The Supreme Court, in Arthur v. Morgan, 112 U.S. 495, 5 S. Court 241, 28 L. ed. 825, held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. 17 Hillhouse vs. United States, 152 F. 163, 164. Second CIR. 1907, a citizen has the right to travel upon the public highways and to transport his property thereon. State v. Johnson, 243 p. 1073, Cummins v. Holmes, 155 p. 171, Packard v. Banton, 44 S. Court 256, Hadfield v. London, 98 Wash 516, Willis v. Buck, 263 PL 982. 19 Chicago Motor Coach v. Chicago, 169 NA 22. Ligier v. Chicago, 28 NA 934, Boone v. Clark, 214 SSW 607, 25 Muir. First. Highways. Sect 163, the right of the citizen to travel upon the highway and to transport his property thereon in the ordinary course of life and business, is the usual and ordinary right of the citizen, a right common to all. 18 Barney v. Board of Railroad Commissioners. 17 P2D 82, the use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. 20 Ex parte Dickey v. Davis, 85 SE 781. Every citizen has an unalienable right to make use of the public highways of the state. Every citizen has full freedom to travel from place to place in the enjoyment of life and liberty. People v. Nuthos, 147. Colo 210. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways, transporting his vehicles and personal property for either recreation or business, but by being subject only to local regulation, i.e., safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. 21 Chicago Coach Company vs. City of Chicago, 337 IL. 200, 169 NE. 22. Traffic infractions are not a crime. People vs. Battle, persons faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise of right, may ignore the law and engage with impunity in exercise of such right. 22 Shuttlesworth v. Birmingham 394 U.S. 147. 1969. U.S. Supreme Court says no license necessary to drive automobile on public highways, streets no licenses necessary. Copy and share freely YHVH. Name 3. The word operator shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. 23 Statutes at Large California Chapter 412 p.83. Highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner. The use thereof is an inalienable right of every citizen. Escobedo v. State 35, C2D 870 in 8 Cal Ur 3D page .27 inches. Right, a legal right. A constitutional right means a right protected by the law, by the Constitution. But government does not create the idea of right or original rights, it acknowledges them. Bouvier's Law Dictionary, 1914, page 2961. Those who have the right to do something cannot be licensed for what they already have right to do, as such license would be meaningless. 24 City of Chicago vs. Collins 51 NA 907, 910. A license means leave to do a thing which the licensor could prevent. Blatz Brewing Company vs. Collins, 160 p.2d 37, 39, 69. Cal. A2D. 639. The object of a license is to confer a right or power, which does not exist without it. 25 Payne vs. Massey 19__196 SW 2nd 493, 145. Text 273. The court makes it clear that a license relates to qualifications to engage in profession, business, trade or calling, thus, when merely traveling without compensation or profit. Outside of business, enterprise or adventure with the corporate state, no license is required of the natural individual traveling for personal business. Pleasure and transportation. 27 Shuttlesworth v. Birmingham 394 U.S. 147. 1969. With regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state. Police authority. Donnelly v. Union. Sewer Pipe County, 184 U.S. 540, LaFerrier v. Grand Trunk R.R. Co., 24A. 848, O'Neill v. Providence Amusement County, 108A. 887. The right to travel, called the right of free ingress to other states, and egress from them, is so fundamental that it appears in the Articles of Confederation, which governed our society before the Constitution. 26 Wingfield v. Fielder 2 DCA 3D 213, 1972. If state officials construe a vague statute unconstitutionally, the citizen may take them at their word, and act on the assumption that the statute is void. 29 Shapiro v. Thompson. Edgerton, Chief Judge. Iron curtains have no place in a free world. Undoubtedly the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty, and the right, ordinarily, of free transit from or through the territory of any state is a right secured by the Constitution. 28 Paul v. Virginia. The right to travel freely from state to state is a right broadly assertable against private interference as well as governmental action. Like the right of association, it is a virtually unconditional, personal right, guaranteed by the Constitution to us all. U.S. Supreme Court. 30 Williams v. Fears, 179 U.S. 270, 274, 21 S. Court 128, 45 L. ed. 186. Our nation has thrived on the principle that, outside areas of plainly harmful conduct, every American is left to shape his own life as he thinks best, do what he pleases, go where he pleases. ID, at 197. 31 Kent v. Dulles C. Vestal, Freedom of Movement, 41 Iowa L. Rev. 6, 13-14. The validity of restrictions on the freedom of movement of particular individuals, both substantively and procedurally, is precisely the sort of matter that is the peculiar domain of the courts. Comment, 61 Yale LJ at page 187. A person detained for an investigatory stop can be questioned but is not obliged to answer. Answers may not be compelled, and refusal to answer furnishes no basis for an arrest. Justice White. Hebel, automobiles have the right to use the highways of the state on an equal footing with other vehicles. 32 Cumberland Telephone and Telegraph Company vs. Yiser 141 Kentucky 15. Each citizen has the absolute right to choose for himself the mode of conveyance he desires, whether it be by wagon or carriage, by horse, motor or electric car, or by bicycle, or astride of a horse, subject to the sole condition that he will observe all those requirements that are known as the law of the road. 33, Swift v. City of Topeka, 43 U.S. Supreme Court. Says no license necessary to drive automobile on public highways, streets. No license is necessary. Copy and share freely. YHVH. Name 4 Kansas 671, 674. The Supreme Court said in U.S. v. Mirsky 1960-361 U.S. 431. An administrative regulation, of course, is not a statute. A traveler on foot has the same right to use of the public highway as an automobile or any other vehicle. 35 Chicago Coach Company vs. City of Chicago, 337 ill. 200, 205, see also, Christie v. Elliott, 216 ill. 31, Ward v. Meredith, 202 ill. 66, Schinkel v. McCullough, 116 KY 960, Butler v. Cabe, 116 Arc. 26, 28-29. Automobiles are lawful vehicles, and have equal rights on the highways with horses and carriages. Daly v. Maxwell, 133 SW. 351, 354. Opel Astra, 34 Checky v. Lindsay, 75 ATL. 376, 377, 1 Boyce. Dell, 185. Automotive vehicles are lawful means of conveyance and have equal rights upon the streets with horses and carriages. 36 Matson v. Dawson, 178 NW2D 588, 591. A. Farmer has the same right to the use of the highways of the state, whether on foot or in a motor vehicle, as any other citizen. 37 Draffin v. Massey, 92 SE2D 38, 42. Persons may lawfully ride in automobiles, as they may lawfully ride on bicycles. Doherty v. Air, 83, NE, 677, 197 Mass. 241, 246. 38 Mulway v. City of Chicago, 88 NE. 485, 486. 239 ill. 486, Smiley v. East St. Louis Rye County, 100 NE. 157, 158. A soldier's personal automobile is part of his household goods. 39 U.S. vs. Bomar, CA5 Tex. 8F3D 226, 235. 19A Words and phrases, permanent. Addition West Pocket Part 94. IT is a jury question whether an automobile is a motor vehicle. 40 United States v. Johnson, 718 F2D 1317, 1324. 5th CIR, 1983. Other right to use an automobile cases. 41 Edwards vs. California, 314 U.S. 160. 42 Twining vs. New Jersey, 211 U.S. 78 Williams v.S. Fears, 179 U.S. 270, at 274 Crandall vs. Nevada, 6 Wall. 35, at 43-44. The passenger cases, 7 Howard 287, at 492 U.S. V.S. Guest, 383 U.S. 745, at 757-758, 1966. 43 Griffin vs. Breckenridge, 403 U.S. 88, at 105-106, 1971 Califano vs. Torres. 435 U.S. 1, at 4, Note 6. 44 Shapiro vs. Thompson, 394 U.S. 618 1969 Califano vs. AZNAVORIAN, 439 U.S. 170. At 176, 1978, look the above citations up in American jurisprudence. Some citations may be paraphrased. As always, do your own due diligence. As I am only a guidepost. It's on you to put your time and energy to obtain the things you desire. Also protect your time and energy. We are not above law, as we only want to follow law and operate in a system correctly.